to it, you've got 4 different lawsuits in state courts where they are challenging Illinois' gun ban, and you've got 4 different lawsuits in federal court that's challenging Illinois' gun ban. We're going to take these next 2 segments here to review some of the latest arguments being made in both the federal and state level courts. Now, with the state level courts, you've got consolidation that's been requested by the attorney that brought the first state level case, Attorney Thomas Devore. He filed with the Illinois Supreme Court to wrap in his 2 Effingham County cases and his White County case, where there are temporary restraining orders in place, including the first Effingham County restraining order being upheld by the appellate court, triggering the other 2 restraining orders. So Devore has those 3 cases. But you have a separate case that was brought forward by State Representative Dan Calkins and his attorney, Jerry Stocks, and that's in Macon County. And that also has a temporary restraining order on it. What's interesting, though, is on February 14th, Attorney Devore, he filed with the Illinois Supreme Court to consolidate those 4 different cases into one case. But you also have Stocks in the Macon County case fighting to have a hearing before what was scheduled for March 20th. Instead, now there seems to be an agreement to move forward with a status hearing on the 3rd of March. So what's going on here is you have somewhat of different legal principles that these attorneys are using to attack the state's gun and magazine ban. In the state level cases, these deal with certain issues, and the issues that Devore has brought up that has at least stuck with the appellate process. They say that there seems to be a likelihood that the plaintiffs in the case, thousands of people signed on as plaintiffs on these lawsuits, there's a likelihood of success on the charge of an equal protections violation. And that's because of what the state says is certain individuals that aren't having to comply with the state's gun and magazine ban, like law enforcement, retired cops. You've got those in the security sector. You've got even jailers and wardens and so on. So the state says that those individuals don't have to comply with the gun and magazine ban. They can go and buy guns from gun stores. Gun stores can sell guns to them, and they don't have to register their firearms starting October 1st, like the rest of us do if you have a firearm on this list of assault weapons. So that's the charge, that this law violates equal protections because it carves out certain individuals to have access to the Second Amendment rights and others don't. That's the allegation. That seems to have carried through thus far, at least the likelihood they'll succeed on the merits of that argument. But there are other issues in the state level cases, and that includes the procedural issues. Did this law pass in a proper manner? Did it follow the 3 readings rule, having 3 separate readings on different days? Did it follow the issue of the single subject rule, having a one subject within a bill? Did it violate the due process of having everybody involved in these negotiations for legislation? So those procedural issues haven't advanced. Doesn't mean they're done, but they haven't fully advanced yet. And none of these issues have in the state level courts. But Attorney Thomas Devore, he's put subpoenas in for his cases to get documents pertaining to discussions and negotiations among all of those who were involved, like Speaker Emanuel Chris Welch, President Don Harmon, the governor's office, and a whole list of other lawmakers. Devore has put subpoenas in, and he's arguing in a live video he did last night. He's arguing that the case that Jerry Stocks is representing Dan Calkins in might too prematurely get to the Illinois Supreme Court and not have these issues fully hashed out and vetted, which he says doesn't give them the ability or the, quote, ammunition or the, quote, weapons to go to the Supreme Court with their argument saying that this is a violation of individuals' rights. There was no rational basis for the so-called training and so on. Here's just some of Tom Devore and his law partner in these cases, Brian Drew, talking about this during a live stream last night.
The only way we win is if we have a record developed to push back. Yeah. And if they go strict scrutiny, it doesn't matter. Everybody's happy. But if they don't go strict scrutiny, which there's a real chance they don't, You cannot win this case on behalf of our clients unless you have all the information that we've gathered and started gathering, like the issue of the wardens. How could they ever explain to the Supreme Court that it's about training when none of your prison wardens have any training with these weapons that have been banned? It's impossible for them to deal with that. But you know what? In Dan Calkins' case, that issue never comes up. Never comes up.
No, it is. I'm frustrated as well, and we want to. I've never seen, and in looking at all these cases through all these years, I've never seen the Attorney General's office fight against consolidating several different cases into one, so they only have to argue at once. I'm sure it may have happened somewhere, and I haven't seen every case that's ever existed. But
we've seen everyone that's existed since COVID, and there were none of them, and we were in all of them.
I got to go to Springfield with everybody else and sit in my line and wait, and because they consolidated them all, the Supreme Court did. This is the only time I've seen the AG's office fight against consolidation, and it's the only time.
Why is the Supreme Court fighting our cases against consolidating the Macon County, Counselor?
What's that?
Why are they fighting it? And they don't want the Macon County case consolidated with ours, right?
Oh no, the AG doesn't because Macon County's agreed not to engage in any discovery. That means the Speaker of the House, that means the President of the Senate never have to raise that right hand, go under oath and say, did you read this bill? Did you gut this bill? Did you do this? Did you do that? They're never going to have to do it. You watch. They haven't answered the complaint. They won't file the first affidavit. Neither one of them will enter into this case in any appreciable way in Macon County at all. In our case, they're going to have to answer that verified complaint under oath. They're going to have to put that right hand up under oath. And that is worth something.
So again, just some of the arguments here on the difference between the Devore cases and the Calkins case, and how Devore and Drew are arguing that Calkins might get to the Illinois Supreme Court too prematurely without the evidence stacked up that they're looking to get from these subpoenas of these various lawmakers. So that's just the state level cases. You have differences as well in the federal cases that have been brought, and what could be the movement towards trying to ultimately consolidate those cases. So we'll get you that update coming up here. So we've been reviewing some of the latest in the cases against Illinois' gun ban, the state-level cases. Got Attorney Thomas Devore in a live stream last night explaining his opposition to the idea of advancing the Macon County case before they get a record built of statements and whatnot from the Senate President, the House Speaker, the Governor's office, and how they crafted and passed this bill, especially when it comes to the issue of training for individuals, because that seems to be the argument that the state has made against the challenge here, saying, hey, law enforcement are properly trained, wardens are properly trained, and so on. So that's the argument the state has made in defense of the law. But apparently the judges thus far say that that's not likely to succeed, and the plaintiffs raising the issue of separation of powers are the ones likely to succeed. So if Calkins' case, which doesn't deal with the issue of training and challenging it on that aspect, according to Devore, if it doesn't build that record, then by the time Devore's cases get to the Illinois Supreme Court, then they won't have that record built, and they'll have different precedents being set, so to speak. So some concerns about how fast Calkins' case might get there versus Devore taking the time to build a record. That seems to be the major differences in the state-level cases. But there's also been some movement in the federal cases. We, of course, had the case of Naperville, where the plaintiffs there had their temporary restraining order declined by a federal judge in the Northern District. And when we talk with John Bach from Gun Save Life, he says that he does not anticipate that impacting the federal cases that they have in the Southern Districts. And here's John Bach from our conversation with him yesterday.
This is just a request for preliminary injunction. This isn't a final decision on the case. And I think a different judge is going to have a very different view on the Bruin decision and its impact on the laws that Illinois has passed.
And he also notes that the Northern District federal judge in that case has already been overturned on 2 other gun issues, the Ezell case from 2010 and the Ezell case from 2014. Bach fully expects that the judge is going to be overturned on this case as well.
So I wouldn't be surprised to see the Seventh Circuit Court of Appeals grant the injunction over Judge Kendall's head. And it's going to be interesting to watch her get slapped down a third time because obviously the Seventh Circuit Court of Appeals knows what the Bruin case means. It knows what the Second Amendment says, and that's going to be that.
So, again, that Naperville case, at least on the federal circuit level, was turned down. They did not advance a temporary restraining order or a preliminary injunction. The judge saying that the Naperville gun ban and the state gun ban is constitutional. Now, also on Friday, the state made a motion to ultimately allow for their response to all 4 cases to have a coordinated briefing. Because if you recall last week, a federal judge said that the state has to show a list of all items banned. And then the state requested a delay in responding to the federal firearms licensees of Illinois case. And the judge denied that motion, saying that there's no harm in the states responding to all 4 cases. So now the state on Friday said, well, we want to respond in a coordinated briefing to all 4. Now, the judge yesterday, Stephen McGlynn, in the Federal District of the Southern District of Illinois, he said that, okay, well, we're going to have a hearing on Friday to discuss this further. And just to show you what that docket entry looks like here, this is from a federal court's monitoring system called PACER. It says the court's in receipt of the agreed motion for entry of proposed stipulation regarding coordinated preliminary injunction briefing for consolidation in this court. This matter is set for a status conference hearing on Zoom Friday. That's coming up this Friday at 10 o'clock to discuss the aforementioned motion as well as consolidation of the 4 cases. So we could see consolidation being discussed in the federal district of the Southern District of Illinois. Todd Vandermeide, another gun rights advocate and who's been helping with the federal firearms licensees of Illinois case, he talked about this briefly last night on his YouTube channel, Freedoms of Steel, and discussed briefly about what this could ultimately mean and what they could hear come Friday.
And that's it. And so with that, Friday morning, we're going to get a status call. The lawyers are all going to be on this Zoom call to hear what the judge has got to say, what his thoughts are on how to proceed with 4 cases that are similarly situated. And we'll get a read on what his take is. I'm sure the Naperville case will come up. I'm sure that there will be the state trying to consolidate everything, even though there are differences among the lawsuits. And we'll see if there's anything else the state wants to bring up. We did see that today one of the state's attorneys that is named in the SAF suit wanted to add more time for their brief. So we'll see what that looks like. We'll see how the judge wants to deal with them. In that case,
he then goes on to talk about other cases with Highland Park, but you get a kind of a sense here that there's some distinct differences between not just the state-level cases, as we heard with Tom Devore and his pointing out the differences with the Macon County case, but also on the federal side. You've got the case that Todd Vandermeide's been working with, the Federal Firearms Licensees of Illinois, that focuses on the gun and parts ban, while the State Rifle Association, the National Shooting Sports Foundation, and the Crawford County case deal with the ban on guns and magazines. So some interesting differences developing here now, a month and 10 days or so in to Illinois' gun and magazine ban. We'll be covering all of the latest twists and turns in a global perspective here on WMAY with Springfield's Morning News. I'm Greg Bishop, and you can always reach out to me via email, bishoponair@gmail.com. Again, bishoponair@gmail.com. bishoponair@gmail.com, or you can follow me on Twitter, Facebook, YouTube. Just search Bishop on Air, and we can connect that way.